is alternative dispute. This is Dr. Ghulam Rabbani, Noyan Bangali, teacher of Washington University. Today, my topic is alternative dispute resolution. This topic is very important. To begin with ADR, I would like to briefly explain my logic for choosing this ADR. First of all, you are my student of MBA. So definitely I'll prefer for your concentration, and I would like to address your career. So it helps students to cover multiple subjects. So why I choose these topics for you again? The topic is highly interested and practiced and practical. Maximizes learning value with one powerful topic. And one subject or topic can be applied for at least 3 different courses, such as business law and organizational behavior and leadership. So if you are a student of MBA and if you want to study organizational behavior, then you can easily understand the conflict in organization, team communication, leadership decision making, managing difficult employees. And even if you are the student of business law, this is a very important part for your business law. Now I would like to say that the ADR does not cover every area. You can ask me, does ADR apply to every dispute? Definitely I will say no. It only applicable in civil cases, employment conflicts, business and commercial disputes, community issues, personal injury, administrative matters, international dispute matters. And ADR does not apply to criminal prosecution, constitution cases, cases needing legal precedent, parties lacking legal capacity, power imbalance situations, emergency cases requiring court orders, mandatory statutory cases such as bankruptcy, immigration, tax, probate, etc. So from my practical perspective, I can also suggest that why I introduce these topics for you and where you can flourish yourself. The university mission statement are very clear. They want to build your career. So through degree, they will give you degree and they will give you skill, and finally you will go to your career. So this ADR will give you career growth with high impact, with strong income. And my top 3 areas for you, my suggestion for you, then you can seek or you can dig yourself your CV or resume for international commercial arbitration, government dispute resolution, court connected mediation, corporate conflict management such as human resource compliance, internal investigation, etc. And today I will focus on importance, theory, logic, model, evidence with data and cases. So many people are confused about what is dispute resolution and what is conflict resolution. Both seem similar, but they are not similar. I want to clearly identify the difference between ADR and SEER. So ADR is a narrower and refers specifically to formal structured alternatives to court, such as mediation, arbitration, negotiation, and conciliation. And on the other hand, conflict resolution is a broader concept. It includes any method, formal or informal, used to manage or solve conflicts between individuals or groups. It's a broader aspect. So same thing again, we can differentiate ADR is more structured and often follows legal or organizational procedure. In contrast, conflict resolution can informal, just like talking it out, peer discussion, diplomacy. The ADR focused on reaching a settlement or agreement outside the court system, but conflict resolution focused on improving relationship, communication, and understanding. ADR usually involves trained third parties like mediators, arbitrators, conciliators, or legal professionals. But conflict resolution, anyone can be involved. You, friends, you teachers, leaders, anyone can be a conflict resolution actor. And ADR typically happens in professional environment such as mediation center, arbitration panels, etc. But conflict resolution you can do anywhere in any places, at your home, office, garden, wherever you like. The outcomes of ADR is legally recognized or formally documented outcomes. But conflict resolution goal is harmonious, and their motto is to building relationship. And ADR explicitly designed to be an alternative to court litigation, but conflict resolution not necessary to connect it with the court. Now I would clearly define the importance. Why it is so important? Because it keeps you out of court and save time and money. It teaches you how to manage conflict professionally. It makes you more valuable in any workplace. It strengthens leadership and decision making. It reflects how modern justice is actually work. Whatever I say, you need some data. And this data is very clear. I want to clearly focus on the data of Florida state. If you can see that in 2022, Florida courts ordered 10 of thousands of mediation and arbitration cases statewide. In 2023, I don't have a specific number, but ADR case orders increases more than past year. In 2024, 60,000 plus ADR cases ordered statewide, mediation, arbitrator combined. So why it is important for you? I defined important for overall importance earlier, but now I want to emphasize that it is very important for you because it prepares you for real world situations where conflicts happen in workplace, team, and organization. It helps you build communication and listening skills that are useful in every class and group project. It teaches you how to handle disagreements calmly and professionally. It builds confidence in negotiation, problem solving, and decision making. It helps you understand how to resolve issues without relying on formal punishment or legal action. So from an academic perspective, I decided to show you the 5I aspect: importance, implication, instruments, innovation, and impacts. So I discussed importance. Now I can clearly, elaborately discuss about implication, instruments, innovation, and impacts. What are the implications? ADR affects how organizations handle disputes internally, encourages a culture of fairness, transparency, and accountability, shapes policies on employee relations, customer complaints, and contract disputes. And now that is very important thing is instruments. This is a crucial part of ADR. Without understanding ADR instruments, you cannot fully a part of ADR. So we can approach this step by step. Mediation is neutral third party helps parties reach agreement. Arbitration is third party makes a binding or non-binding decision. In negotiation, parties work directly to find a solution. Conciliation, mediator plays a more active guiding role. In facilitation, help group discuss issue and make decision. So innovation part, whenever we discuss innovation, the first question you may ask, what ADR has innovated or improved? We also naturally compare old innovation with new one and try to show that today's innovation is better than yesterday. ADR promotes creative, flexible solutions that courts cannot offer. Parties can design outcomes tailored to their real needs, not just legal rules. Encourages problem solving through collaboration instead of punishment. And nowadays, people are very revenge oriented, So my innovation is culture of compromise. So culture of compromise is that a compromise is an art of dividing cake such a way that everyone believes they got biggest. Impact. Impact improves relationship by preserving trust between parties, increases workplace productivity by resolving issues faster, and strengthening leadership credibility because leaders who managing conflict will gain respect. So I'd like to add one more important impact of resolving disputes through ADR. That is reputation. Whether it is personal, business, and when dispute go to court, extensive social media exposure, press coverage can seriously damage image, credibility, dignity. Dignity is as important as food. So ADR offers soundless, noiseless, and publicity-free solution, allowing parties to resolve conflict privately and respectfully. So now it is the time for sequence. ADR sequence. So ADR sequence is very important. Sequence means the step-by-step process or path follows in ADR. So our student need to understand this process like a driver understand how to run a car. I will discuss the sequence in details and we can approach this step by step. Initiation. So both parties propose using ADR. They agree the types of process. Information sharing. The parties meet, structural session to share their perspective. Issue identifies. So neutral identifies the key issues in dispute. The clarity, misunderstanding, and narrow down the contention. Find solution. The parties brainstorm to find possible solution. And formalization. This possible solution they can formalize, and finally it will be follow-up session. Follow-up on the implementation of resolution. Strategies. So strategies is also your strategy how to do these things. So active listening is a good strategy, and empathy. Clear constructive communication. Identify the real cause. Encourage collaboration and compromise. Set clear expectation and boundaries. Manage emotions and stay neutral. Now I'll show model, because model is important to understand what model we are using for ADR. Thomas Kilmann model is one of the most popular model. This is a Thomas Kilmann conflict mode model. So leader can use this model to self-diagnose their default style and then adapt to more effective styles as needed. Normally for divorce cases, family issues. So husband or wife, they actually doing blame game. But if they can analyze themselves, self-diagnosis, so we can use this model for those cases. Harvard model is very popular model because it is called principal negotiation approach. That's why it is very famous. It encourages focusing on interest, not position. This means looking beyond what you want. That means what your position, and understanding why they want it. That is the interest. So you have to focus on interest, why they want it. Union management negotiation model. I was a trade union leader earlier, 1994, and I understand what is very strong part of your skill in this CBA, bargaining system. So as a bargaining agent, so this union management negotiation model is very important. Many labor disputes have been successfully resolved through ADR. And one of the very important model is common ADR spectrum model. from lowest intervention to highest intervention. Any dispute shall first be negotiated between executives. If not resolved in 30 days, it will proceed to mediation. If still not resolved, it goes to arbitration. Now I will present a few examples and cases to capture your interest and encourage deeper understanding. These examples and cases are well known and involves major companies, which will help you realize the significance of the subject. Starbucks and labor union. The point of dispute is allegation of unfair labor practices, allegation of union recognitions, and workplace conditions. So ADR worked here, and their tools is mediation facilitated by labor authorities. And ADR helped to reduce strikes, minimize public conflict, and kept store operation running. So what result gained from this ADR? Some dispute resolves through negotiation agreements rather than lengthy court process, and also save reputation of Starbucks. Microsoft and TikTok, very interesting case. Microsoft versus TikTok. You know, TikTok, once upon a time, the name was a Byte Dance or Byte Talk, something like this. And the main conflict of the dispute was national security concern, because lots of data privacy are going from USA to other country, because TikTok owner were from China. So how ADR worked? The ADR worked through their tools, facilitated negotiation-based ADR. And ADR helped to allow rapid confidential discussions without initiating, avoid complex international litigation. So what result they gained? They gained litigation was avoided, regulatory risks were managed, and corporate relationship remained intact. Apple versus Samsung. I know this case, finally they are not settled by the ADR arbitration, but few cases, several claims were settled by these. Their conflict was design patents, you know, and utility patents. And that was their conflict point. And court requires mediation and settlement conferences. And ADR helped to limit disclosure of proprietary technology and reduced prolonged multi-country litigation cost. Wow, this is one of the major, renowned and popular case in the world. BMW versus Rolls-Royce. You know, BMW purchased Rolls-Royce cars, motor cars. The name is Rolls-Royce. Mind it, name is Rolls-Royce motor cars in 1998. After the purchase, you know, BMW was informed that it could not use the Rolls-Royce brand or logo, because these rights were owned by Rolls-Royce PLC, which was their aerospace engineering company. So my God, what it takes. They have a different company, but Rolls-Royce motor cars, they don't have this trademark patent, but their trademark patents owned by Rolls-Royce PLC. So this dispute continued for nearly 2 years. Initially, arbitrator decided for brand sharing. Okay, you can, BMW can use Rolls-Royce, they can also use Rolls-Royce, but finally it looks not good. So in 2003, BMW ultimately obtained full rights to use Rolls-Royce. It's a very interesting case. And what ADR helped? ADR helped prevented reputational damage and allowed flexible business solution beyond court imposed outcomes. And BMW obtained finally Rolls-Royce motor cars rights for using these things, and their dispute was the trademark rights, basically, and branding authority. Very interesting case. Now we need to understand few math. You know, mathematics is very important, and mechanism and modality is the part of my mathematics, and I'll show you some formula. I know you cannot see anywhere the ADR. When the teacher are taking the class, they will not show you any math for this ADR, but fortunately you are very lucky that I'm showing some formula how to be a good arbitrator, and you can be a best ADR actor. So how it works? So both works, mechanism sets the structure, and modality adjusts the delivery. So ADR outcomes, mechanism plus modality. And also the effective ADR formula is the right mechanism plus right modality plus party willingness. And ADR efficiency comes from time plus cost plus confidentiality. And what is right mechanism? The right mechanism, if you use all right tools, right instruments. Right instruments are negotiation instruments, mediation, conciliation, arbitration. So parties communicate directly in negotiation. And mediation, neutral third party facilitates discussion. In conciliation, neutral facilitates and propose solution. In arbitration, neutral third party decides the disputes. So modalities of ADR, how the mechanism is delivered. So the mechanism is delivered, sometimes binding, sometimes non-binding, formal, informal, in person. And ADR tactics. So you can ask me the strategy, sequence, tactics, all look same, but all are not same. All are different style to learn. If you can ask me strategy and tactics, what is the difference? Strategy is the average for overall strategies. But when you talk about tactics, you have to talk about the specific cases. You have to concentrate on any specific issue, then you can follow this tactics. Primary stage, final stage. In the primary stage, you can clarify the issue, build trust, sell ground rules, early neutral evaluation, interest-based discussion, brainstorming. And for final stage, you reality testing, private caucuses, package deals, final negotiation and drafting, agreement closure. So what are the challenges of this area? Lack of commitment, power imbalance, no guaranteed resolution, limited appeal, cost misconception, stalling and bad faith practice, enforceability, cultural and personal barriers. So what future you have? It opens career paths for you. HR and organizational leadership, law and legal consultancy, government and public policy, international relation, business management and corporate negotiation, community development and social work, peace building and diplomacy. So what professional name or conflict resolution experts use? They can use as an arbitrator, their brand, arbitrator, neutral arbitrator, arbitrator panelist. If you practice mediation, mediator, certified mediator. If you are broadly in ADR, so ADR specialist, ADR practitioner, conflict resolution specialist, dispute resolution consultant, negotiation and mediation expert. If you teach or advise an ADR trainer, conflict management consultation, negotiation consultant. So I'm working as a conflict management consultant. So same things, your professional goal, how it works. Some states certify mediators for court-connected cases. Requirements vary 20 to 60 hours of mediation training if you get the training. Even I'm giving you training. So for today, I'm giving you 30 minutes training. So this training, I can give you 20 to 30 hours training for this certification. Observations, you can observe, work as an observer. They will check your background and need ethics requirements. So some states they need certificates, some states they don't need. Florida certification system for civil, family, county dependency mediators. Virginia court certified mediator program. In Virginia, we live in Virginia, so here you need court certified mediator program. In California, no formal certification needed, you know. So after completion your program course, and if you want to become an arbitrator or mediator, so you also can join different apex body association. This is very important for you to be a part of this membership, and then you can build your network, build your leadership. You can join American Bar Association in section of dispute resolution. You can join also Association for Conflict Resolution, ACR, American Arbitration Association, AAA, and CPA JAMS panel and CPA Institute of Dispute Resolution. So finally, for going